Hello, my name is William Freeman and I'm Civil Law Notary number 10 in Alabama. A civil law notary is an attorney with special training and at least 5 years of practice who has passed an exam which authorizes him to make findings of fact and conclusions of law as a juridical officer on behalf of the state of Alabama, just like a judge or jury. Civil law notaries can and will authenticate any transaction, event, or occurrence in the absence of controversy. They act as counsel to the transaction. A civil law notary is not a tool to authenticate facts in anticipation of litigation or during litigation or someone to fight for one party against another. The civil law notary is accountable to all the parties and to the state of Alabama. The office of civil law notary is not a new idea, as it became a fact in continental Europe in the 12th century. It's not limited to international transactions, and it's not a rubber stamp. A civil law notary is not the same as a notary public. A civil law notary is a specially trained and certified individual that is an attorney practicing in the state in order to represent the transaction, not individuals or parties to the transaction. Ideally, the civil law notary brings a balance between parties, with the parties equally protected and each party given complete legal advice as to the consequences of their transaction. This reduces the scope of litigation by limiting matters which can be disputed in our courts later. A good example is the testamentary capacity and intent of a testator in a will contest. In contracts, the notary removes issues that can later be used to bring lawsuits, such as whether there was capacity to sign on behalf of a corporation or whether contract's conditions have been met. The state looks at the transaction as having an ironclad binding when it is thus notarized by a civil law notary. The court looks at documents signed by civil law notaries as having the full weight and measure of Alabama law. This gives all transactions, including international transactions, a much greater comfort level, especially for non-U.S. companies used to operating within the protections that a notary brings to transactions. The civil law notary also makes transactions acceptable in most foreign courts and accepted by foreign notaries, cutting red tape and delays by establishing valid powers of attorney for overseas signature on documents. The civil law notary may also authenticate copies as original and verify facts internationally and to an international standard. Civil law notaries impartially represent the transaction, armor-plating the transactions with legal certainty under law. Without the work of a notary in this way, findings are otherwise left up to riskier litigation in the courts of Alabama. The notary makes the document strong with foreign businesses, foreign notaries, and foreign courts, and domestic courts, cuts red tape, and by the use of best practices, best protects the parties and the transaction. The domestic use of civil law notaries appears to have just as much potential. Aren't your private transactions, like your contracts or your will, at least important enough to consider using a civil law notary?